Hi everyone, in this week's video we are discussing the without prejudice rule and the extent of its application. So when can that rule be abused and when can the protection afforded by that rule be disapplied by a tribunal? So the without prejudice rule is essentially the off-the-record rule. It generally prevents oral or written statements made in a genuine attempt to settle a dispute from being put before a court or tribunal as evidence of admissions against the party making them. So it's particularly beneficial in circumstances where employer and employee are looking at parting company and making offers on an off-the-record basis. The protection is that if those discussions break down, hopefully the discussions cannot be referred to in any future proceedings. Now, we have a case recently in the Employment Appeals Tribunal which is very helpful because it analyses the extent to which that rule can or can't be abused. One of the exceptions to the rule is that where one party uses this as a cloak for unambiguous impropriety, they may lose the protection of the without prejudice rule. And in some cases, employees will try and use that to their advantage. So if a settlement offer has been made and discussions break down, the employee may try to use that offer as essentially an admission of liability to boost their case, or as an example of unfair treatment that they've suffered from their employer. Now, the case in the Employment Appeals Tribunal demonstrates the high threshold which has to be met in order for the without prejudice protection to fall away. In this case, an employee copied 3 emails to her personal email address when sending them to her employer as part of a grievance. The emails contain personal data, which is subject to the Data Protection Act and GDPR, and matters which were confidential to the company and its clients. Before offering to settle the complaints, the employer sent a letter to the employee which alleged that she had breached confidentiality obligations in a contract, had committed a criminal offence under the Data Protection Act, and that she might have acted in breach of the integrity rules pursuant to the Financial Conduct Authority provisions. The letter said this could result in summary dismissal, it could result in criminal convictions, fines, and FCA findings which could make it difficult to work in the regulated sector. So all of these matters were put into a without prejudice letter. The question for an employment tribunal was, does that content amount to unambiguous impropriety? And should the company lose the protection of the without prejudice rule? So originally at the Employment Tribunal, the judge decided there was no basis for the employer's assertion that there was serious misconduct. They said that the allegations had been grossly exaggerated in order to put pressure on the employee to accept a deal, essentially. And so the company lost the protection of the without prejudice rule. The matter went before the Employment Appeals Tribunal, and they considered that the judge's decision at the original hearing was incorrect. They considered there was a very high threshold for unambiguous impropriety. It could be met in circumstances where a party had made exaggerated allegations, although there were without any findings on the guilty party, so in this case the employer's state of mind, it would be very difficult to meet that threshold. So there's a couple of previous cases which the Appeals Tribunal found very helpful in analysing. The first one is Förster and Förster, which did fall within the unambiguous impropriety exception. So in this case, an email was sent to an individual, it was in the context of a corporate matter, offering to buy shares at an increased price. The email stated that the offer was being made on the basis further wrongdoings had come to light. It was in their interest to wrap things up speedily and quietly, and a deal would remove the need to consider additional proceedings such as committal proceedings. The court in that case said that that exceeded what was permissible in settlement litigation. It went far beyond what was reasonable and threatened criminal action, had serious implications for the individual's family, and there was an attempt to obtain a financial advantage. Crucially, there was no connection between what was being alleged and the increased demand that was made by the party making the offer. The second case is Motorola Solutions and Hytera Communications, Essentially, the summary in that case is that the unambiguous impropriety exception can only be applied where the conduct is truly exceptional. So that demonstrates there's a very high threshold. And when the Employment Appeals Tribunal analysed the current case, they accepted there were some similarities with Firster. There was a threat of criminal proceedings, but there were significant differences. So the threats were not baseless, essentially. There was a connection between the conduct that the employee was alleged to have committed and the proposed settlement. This had clear relevance to the employment relationship. However, it was noted that the employer sailed close to the wind. So there is no absolute prohibition on suggesting that there may be criminal consequences or civil consequences if somebody does not accept a without prejudice offer. I think what is clear in this case is that firstly, we mustn't exaggerate those allegations. We must have a sound foundation for making those allegations, and that has to be put to the individual in the context of settlement proceedings. It's a very helpful case because we, as part of settlement negotiations and trying to obtain as much leverage as possible, if there are serious allegations, and particularly in a data protection context, there are criminal repercussions if somebody does unlawfully misuse personal data, we will want to include such allegations without prejudice correspondence. I think this case just simply demonstrates that where we're going to do that, we must have a proper basis for putting those allegations to the employee and must only go so far in stating what those repercussions are without exaggerating too far. So, very difficult area to advise on, a grey area as so much of employment law is. If you do need any further assistance on this type of advice or any employment matter generally, please do visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.